Before we start with the tutorial, we would love to hear your views about today's topic or our tutorials in general. We appreciate the impact we have on your studies, and we wish to learn how we can improve our tutorials for you. Introduction to Law 202 Presence. Criminal Procedures, Legal Theories of Bail. This tutorial is drafted and presented by CV, where your coolest online tutor. The tutorial is voiced by and with assistance from a text-to-speech generated commands. It takes a lot of time and care to prepare these lessons for you. If you have any questions, please leave a comment below. I would love to hear your views on our tutorial. We will first discuss the implication of the accused's constitutional rights in bail application. Our history instructs us that it is a matter of pride that South Africans value and assert our freedom above all other considerations in the face of whatever adversity we chance upon to meet. Our law must guard that right and its exercise unreservedly. According to paragraph 2 of the cited case, the effect of superimposing the norms of a rights culture on our criminal procedure and justice system is no exception to bail application. So much of concern has been directed at the granting or refusal of bail. The advent of a constitutionally based human rights culture, and specifically the demands of Section 35, subsection 1F of the Constitution, requires an acknowledgement. Section 35, subsection 1F of the Bill of Rights provides that everyone who is arrested or allegedly committing an offense has the right to be released from detention if the interests of justice permit, subject to reasonable limitations. Section 35, subsection 1F in its context makes three things plain. The first is that the Constitution expressly acknowledges and sanctions that people may be arrested for allegedly having committed offenses and may for that reason be detained in custody. But Section 35, subsection 1F neither expressly nor impliedly requires that in considering whether the interests of justice permit the release of that detainee pending trial, only trial-related factors are to be taken into account. The Constitution itself therefore places a limitation on the liberty. Notwithstanding lawful arrest, the person concerned has a right, but a circumscribed one, to be released from custody subject to reasonable conditions. This sets the normative pattern for the law of bail. It is that the criterion for release is whether the interests of justice permit it. That Section 35, subsection 1F postulates an evaluation of different factors that make up the criterion of the interests of justice, and that the basic objective traditionally ascribed to the institution of bail, namely to maximize personal liberty, fits snugly into the normative system of the Bill of Rights. It is accordingly important that the rules of that institution, which are said by some to be at odds with those values, be scrutinized. This takes us to the next subtopic, the regulatory framework of bail applications. Chapter 9 of the Criminal Procedures Act is where the effect, rules, and consequences of bail are primarily to be found. Chapter 9 of the CPA is not only an invaluable point of reference in any general inquiry into the law of bail, and a primary source to be consulted in looking for an answer to any specific bail question, but provides a comprehensive framework. The chapter creates a complex and interlocking mechanism that is clearly designed to govern a whole procedure whereby an arrested person may be conditionally released from custody, prescribing the components of that mechanism in minute and sequential detail. The legislature, in formulation of the chapter, intended to provide a comprehensive, if not exhaustive, set prescripts governing the whole procedural terrain of bail. The general observation to be made about Chapter 9, arising from the overview, is that the grant or refusal of bail is unmistakably a judicial function. The link between rights for personal freedom and bail processes. There are various methods of securing the attendance of an accused person in court, and with the most invasive of those methods, namely arrest. The underlying policy is plain. Although societal interests may demand that persons suspected of having committed crimes forfeit their personal freedom pending the determination of their guilt, such deprivation is subject to judicial supervision and control. Moreover, in exercising such oversight in regard to bail, the court is expressly not to act as a passive umpire. If neither side raises a question of bail, the court must do so. If the parties do not of their own accord deduce evidence or otherwise produce data regarded by the court to be essential, it must itself take the initiative. Even where the prosecution concedes bail, the the court must still make up its own mind. In principle, that policy of the CPA and the consequential provisions mentioned are in complete harmony with the Constitution. Legal nature of bail proceedings. A bail hearing is a unique judicial function. It is obvious that the peculiar requirements of bail as an interlocutory, although it is intended to be a formal court procedure, it is considerably less formal than a trial. The evidentiary material proffered need not comply with the strict rules of oral or written evidence. Although bail, like the trial, is essentially adversarial, the inquisitorial powers of the presiding officer are greater. An important point to note here about bail proceedings is that it is often overlooked. It is that there is a fundamental difference between the objective of bail proceedings and that of the trial. In a bail application, the inquirer is not really concerned with the question of guilt. The court hearing the bail application is concerned with the question of possible guilt only to the extent that it may bear on where the interests of justice lie in regard to bail. The focus at the bail stage is to decide whether the interests of justice permit the release of the accused pending trial, and that entails in the main protecting the investigation and prosecution of the case against hindrance. Function of bail in the South African criminal justice system. For the first time in South African bail legislation, during the advent of the Constitution, attention is focused not on the accused but on the community. The functions of bail are also to protect the fundamental rights of many thousands of arrested persons and with bearing on the day-to-day administration of the criminal justice system. With parity to the polarizing interests, bail serves as a remedy of a valued judgment taking into account the arrested person's right to liberty, as qualified by the lawful arrest. The constitutional obligations during bail proceedings are now placed on police and prosecutors to respect, protect, promote, and fulfill the rights in the Bill of Rights, and in particular, the right of women to have their safety and security protected. In turn, courts have a constitutional duty to uphold the constitutional values. Duty of police in bail applications. The police is one of the primary agencies of the state responsible for protection of the public in general and women and children, in particular against the invasion of their fundamental rights by perpetrators of violent crime. Section 205, subsection 3 provides that the object of the police service are to prevent, combat, and investigate crime to maintain public order, protect and secure the public, and uphold and enforce the law. As a result, the police service have a duty to bring to the attention of the prosecutor any factors known to him relevant to the exercise by the court of its discretion to admit an accused person to bail. Duty of prosecutors in bail processes. Although the consideration of bail is preeminently a matter for the presiding judicial officer, the information available to the judicial officer can but come from the prosecutor. He or she has a duty to place before the court any information relevant to the exercise of the discretion with regard to the grant or refusal of bail, and, if granted, any appropriate conditions attaching thereto. The role of prosecutors during a bail application is to protect the public interest, act with objectivity, take proper account of the position of the suspect and the victim, and pay attention to all relevant circumstances, irrespective of whether they are to the advantage or disadvantage of the suspect. To make a mistake will have a chilling effect on the exercise by prosecutors of their judgment in favor of the liberty of the individual. There is no reason in principle why a prosecutor who has reliable information, for example, that an accused person is violent, has a grudge against the complainant, and has threatened to do violence to her, if released on bail, should not be held liable for the consequences of a negligent failure to bring such information to the attention of the court. If such negligence results in the release of the accused on bail, who then proceeds to implement the threat made, a strong case could be made out for holding the prosecutor liable for the damages suffered by the complainant. Duty of court to protect the public in bail applications. The courts are under a duty to send a clear message to the accused, to other potential criminals, and to the community. Bail procedure remains a unique interlocutory proceeding where the rules of formal proof can be relaxed and where the court is obliged to take the initiative if the parties are silent. And the court still has to be proactive in establishing the relevant factors. More importantly, the basic inquiry remains to ascertain where the interests of justice lie. The interests are informed by the information available to the court. In deciding whether the interests of justice permit the release on bail of an awaiting trial prisoner, a court must also consider the interests of society. Therefore, a court is required to make a valued judgment of what would be fair and just to all concerned. But while this is a court's strength, that is also its potential weakness. Balancing interests in bail applications. There are far too many persons awaiting trial in our prisons, either because bail has been refused or because bail has been set in an amount which cannot be paid. There is a close relationship and appropriate fit between the temporary withholding of liberty and the disruption that release would unleash. Courts are also alive to the danger of public sentiment being orchestrated by pressure groups to serve their own ends. Refusal of bail fulfills the confidence the public has in the justice system and the assurance the public deserves that bail will not be granted to those who keep committing offenses whilst they are awaiting trial. In granting or refusing bail, courts rely on these bases with great circumspection in the knowledge that the Constitution protects the liberty interest of all. Challenges to bail granted or refused. Cancellation of bail is tantamount to a refusal of bail. It is appealable or reviewable depending on challenges to the bail granted or refused. This concludes our tutorial. Our next tutorial will be on debt reviews. Our next lesson will possibly be uploaded around June or July, as I will be taking a break from my tutorial program.